Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Imagine looking at a headline. The date is March 4, 2026.
Okay, I'm picturing it.
And blazing across your screen is this jaw-dropping number, a $2.5 billion payout.
Wow. That is a lot of zeros.
Right. And when you see a number with that many zeros, I mean, your mind immediately jumps to a few obvious conclusions.
Sure, you'd think like a tech monopoly getting slapped with a huge regulatory fine in Europe or something.
Exactly. Or maybe, a hostile corporate buyout of some mid-sized software company.
Right.
But this $2.5 billion check, it wasn't written over social media algorithms or search engine dominance. It's actually about microscopic capsules.
Which is wild to think about.
It really is. It is a story about the hidden, essentially invisible architecture of modern medicine. So welcome to today's Deep Dive.
Glad to be here for this one.
Our mission today is to look way past the standard headlines of the COVID-19 vaccine that we all live through. We're going to uncover the high-stakes, multi-billion-dollar legal battles over the actual delivery mechanisms of modern therapeutics.
Because that's where the real drama is.
Yeah. Okay, let's unpack this.
Well, it's the sheer scale of the settlement that really forces you to pay attention. $2.5 billion resolves a dispute that has been brewing for years.
Long before the pandemic, right?
Oh, absolutely. Long before anyone had ever heard of a spike protein. What we are looking at is basically a masterclass in how modern scientific innovation, global public health, and complex intellectual property law all collide.
It's like a massive intersection.
Exactly. We are looking at a system where mapping the genetic code of a virus is really only a fraction of the battle.
Right.
The real bottleneck, and honestly, the source of this massive financial settlement, is the physical transportation of that genetic code into a human cell.
Okay, so let's start right there with that physical transportation.
Yeah.
Because if you follow biotech at all, you know the basics of mRNA.
Right, the messenger RNA.
Yeah, it's essentially a string of genetic code, like a set of instructions. But mRNA on its own is incredibly fragile, isn't it?
Highly fragile. And it's also massively large on a molecular scale.
And crucially, it carries a negative electrical charge. Our cell membranes are also negatively charged.
Right, so you have two negatives.
Exactly.
Yeah.
So if you just inject raw mRNA into the bloodstream, not only will enzymes rapidly chop it to pieces, but even if it survives, it will literally bounce off the cells it's trying to enter.
Because those two negative charges repel each other, just like magnets.
Right, so you can't just toss in the bloodstream and hope it works.
Which is the fundamental biological hurdle that literally took decades to overcome. You have this therapeutic payload that the body's natural defenses just view as foreign debris.
Like an invader.
Yeah. Blood enzymes, specifically ribonucleases, will degrade naked mRNA in a matter of minutes.
Wow, minutes.
Just minutes. To get it inside the cell, you need a highly specialized vehicle. And that vehicle is the lipid nanoparticle, or LNP.
The LNP, okay.
The LNP is what actually makes mRNA therapeutics physically possible. Without it, the greatest genetic sequence in the world is clinically useless.
I want to frame the LNP for you listening, because it's often glossed over in the news as just a fat bubble.
Yeah, that term definitely doesn't do it justice.
Right. It's so much more engineered than that. Think of the mRNA like an incredibly valuable but highly fragile glass sculpture.
Okay, I like that analogy.
You can't just toss a glass sculpture in the mail and hope it arrives intact. You need specialized packaging. The lipid nanoparticles, the LNPs, they are like high-tech, shock-absorbent, armored delivery trucks.
That's a great way to put it.
They safely transport this fragile genetic material right into human cells. Actually, it's almost like a microscopic, programmable stealth bomber mixed with a Faraday cage.
It really is, because it has to hide the mRNA from the immune system radar first.
Right, the stealth part.
Then it has to safely navigate the turbulence of the bloodstream.
Yeah.
And then finally, it has to perform a really highly specific biochemical docking sequence to drop the payload inside the cell.
All without destroying the cell itself in the process.
Exactly. And the engineering of that stealth bomber is incredibly precise. That precision is basically the root of this entire legal war.
So what actually goes into making one of these LNPs?
Well, an LNP is typically composed of 4 distinct lipid components, and each one has a very specific job.
Okay, 4 components.
Yeah. First, you have structural lipids that give the capsule its shape. Then you have cholesterol.
Wait, like the cholesterol in food?
Similar molecule, yeah.
Yeah.
In this case, it adds stability to the membrane, so the whole thing doesn't just fall apart in the blood.
Oh, interesting.
Then third, you have pegylated lipids. That's lipids attached to polyethylene glycol. These act like the stealth coating.
Ah, so that keeps the immune system from spotting it.
Exactly. It prevents the nanoparticles from clumping together and hides them from immune cells. But the absolute magic and the core of the intellectual property dispute lies in the fourth component,
Which is?
the ionizable lipid.
Ah, right, because the ionizable lipid is the piece that solves that electrical charge problem we talked about.
Exactly. It neutralizes the negative charge of the mRNA so they can be packed tightly together inside the capsule.
But here's where it gets really fascinating, right? It doesn't just stay neutral.
No, it doesn't.
Once the LNP is swallowed by the human cell, it ends up trapped in this acidic compartment called an endosome.
Right, the cell's sorting center, basically.
Yeah, and as the environment gets more acidic, that ionizable lipid suddenly changes its structure. It takes on a positive charge.
Which is the trigger.
Right. The positive charge basically causes the endosome to tear open, releasing the mRNA directly into the cell's cytoplasm where it can actually get to work making proteins.
It is a highly choreographed molecular escape act.
It's like a Trojan horse bursting open.
Exactly. And choreographing that escape act requires an exact, mathematically perfect recipe.
You can't just eyeball it.
No, you can't just throw those 4 lipids into a vat and hope they form an LNP. You need highly specific molar ratios.
Like a very strict baking recipe.
Right. How much cholesterol compared to how much ionizable lipid?
Yeah.
What is the exact chemical structure of that specific ionizable lipid?
And companies spent, what, years figuring this out?
Years and hundreds of millions of dollars tweaking these ratios by fractions of a percent. They had to find the one combination that didn't just work in a petri dish, but worked safely in humans.
Because if you get it wrong, it can be toxic, right?
Yeah, you could cause massive liver toxicity. So getting the math right was a massive achievement.
Which brings us to the combatants in this multi-billion-dollar fight. So if this armored delivery truck is just as essential as the genetic cargo it carries, it raises a huge question. Who actually owns the truck?
That is the $2.5 billion question.
So on one side of this Delaware courtroom, you have Moderna, the company that successfully commercialized the vaccine and became a household name.
Right.
And on the other side, you have Arbutus Biopharma and Jidavant Sciences.
Who are definitely not household names.
Not at all. But Arbutus had been working on lipid nanoparticle delivery for years. They were primarily trying to deliver a different kind of genetic medicine for hepatitis B.
Right. They were pioneers in the LNP space.
Yeah, and they figured out the specific molar ratios of those 4 lipids to make the stealth bomber work effectively and safely. And crucially, they patented those ratios.
They did. Arbutus and their licensee Genevant hold a portfolio of patents that basically cover the foundational architecture of the modern LNP.
So they own the blueprints.
Exactly. Their claim in the lawsuit was straightforward. They said, when Moderna built the COVID-19 vaccine, they didn't invent a new delivery vehicle from scratch.
They just used the one Arbutus already made.
Right. They claimed Moderna utilized the specific lipid ratios and formulations that Arbutus had already spent decades perfecting and patenting.
So Arbutus essentially said, you mapped the mRNA payload, but you put it in our proprietary delivery truck.
Yeah, without asking. And about paying for the license.
You know, I struggle to feel bad for Moderna in that specific scenario. I mean, if you are operating in the biotech space, you know exactly who holds the patents for delivery mechanisms.
You definitely do. There are whole teams dedicated to just that.
Right. You do an extensive patent search before you ever run a single clinical trial. So if Moderna knew that Arbutus held the patents on these specific LNP formulations, why not just license them from day one?
Well, that's where the strategy comes in.
But why use the technology, build your entire flagship product around it, and just wait to get sued? I mean, is it arrogance, or is there a strategic reason you'd ignore a massive patent roadblock?
What's fascinating here is that it is heavily strategic. It revolves around a concept in biotech called freedom to operate.
Freedom to operate, okay.
Yeah. When a company is developing a new therapy, they do not want to be beholden to a competitor's intellectual property if they can avoid it.
Because it costs them money.
Money and control. Licensing early means giving up a massive percentage of future royalties. Plus, it gives the patent holder leverage to dictate how you can actually use the tech.
Ah, so Arbutus could have said, you can use it for vaccines, but not cancer drugs.
Exactly. So Moderna's argument wasn't simply, we ignored your patent. Their argument was, we innovated past your patent.
Oh, I see.
They claimed they used a novel, proprietary ionizable lipid that they invented themselves, and they argued that the specific ratios they used for the COVID vaccine fell outside the legal boundaries of what Arbutus had actually protected.
So they argued the blueprint was different enough to be considered a completely new vehicle. Like it's not a truck, it's a van.
Exactly. But Arbutus clearly didn't buy that.
Not at all.
They looked at the chemical breakdown of the vaccine's delivery system and basically said, no, this still infringes on the foundational claims of our patents. You may have changed the hood ornament, but the engine is ours.
Man. And this is where patent law and biotechnology gets fiercely complicated, doesn't it?
Extremely, because a patent doesn't just protect one exact, highly specific formulation.
Right. It protects a range.
Exactly. Arbutus's patents covered a range of molar ratios for those lipids. If your formulation falls anywhere within those mathematical boundaries, you are technically infringing.
And Moderna was operating under the belief, or at least the legal strategy, that the Arbutus patents were either overly broad or outright invalid.
Right, because they argued previous scientists had already documented similar ideas, what patent law calls prior art.
Prior art, right.
Yeah.
And Moderna went on the offensive long before the vaccine ever came to market. They didn't just passively accept the claims or wait for a lawsuit.
No, they struck first.
They actively tried to destroy the Arbutus patents. They utilized this legal mechanism called inter partes review, or IPR.
Yeah, the IPR process.
For those of you listening who don't spend your weekends reading patent law, an IPR is basically a process where you go to the U.S. Patent and Trademark Office and say, hey, you guys made a mistake.
Right, you never should have granted this patent to Arbutus in the first place.
Because the idea wasn't actually novel.
Exactly. And the IPR process is really the weapon of choice for clearing a path to that freedom to operate we mentioned earlier.
Because it's easier than going to court.
Much easier. It is faster and significantly cheaper than fighting an infringement case in a federal district court. And critically, it's judged by administrative patent judges who actually understand the dense chemistry.
Rather than a jury of everyday people trying to learn chemistry on the fly.
Right. So Moderna challenged several of Arbutus's key LNP patents through this IPR process.
And how did that go for them?
Well, they won some minor battles in validating certain claims. But crucially, they lost the war. The Patent Trial and Appeal Board upheld the validity of the most critical Arbutus patents.
So Moderna takes their shot at the king, they miss, and the patents survive.
And that sets the stage for the massive collision.
Right. The vaccine rolls out, it generates tens of billions of dollars in unprecedented revenue, and Genevin and Arbutus file a massive infringement lawsuit in the U.S. District Court for the District of Delaware.
They demand compensation for the unauthorized use of their LNP platform.
Which brings us back to the headline. This is the lawsuit that culminated in that $2.5 billion settlement.
Yes.
But here is the piece that requires a real deep dive. This settlement was announced just days before a highly anticipated jury trial was set to begin.
Just days. It was down to the wire.
So if Moderna truly believed their proprietary ionizable lipid was unique, and that their ratios were novel enough to skirt the Arbutus patent, why blink at the 11th hour? Why hand over $2.5 billion?
Well, you have to look at the binary risk of a jury trial in a patent infringement case.
Meaning you either win big or lose big.
Exactly. When you go to trial, you are asking 12 everyday citizens to sit in a jury box and understand the stoichiometric ratios of ionizable lipids.
Yeah, that's a tough ask.
And endosomal escape mechanisms and the historical timeline of prior art in nanomedicine. It is incredibly difficult to predict how a jury will interpret highly technical expert testimony.
I mean, a jury might just see a small biotech company getting crushed by a mega corporation and side with Arbutus purely on optics.
Optics play a massive role, for sure, but the financial math is what really drives a settlement of this magnitude.
The actual damages?
Worse, if Moderna went to trial and lost, the jury wouldn't just award past damages. The judge could potentially grant an injunction.
Wait, an injunction, like legally barring them from selling it?
Legally barring Moderna from using that LNP technology in any future products without paying whatever royalty rate Arbutus demanded.
Oh, wow. And remember, Moderna is an mRNA company.
That's their whole identity.
Their entire pipeline, flu vaccines, RSV vaccines, potential cancer therapies, it all relies on lipid nanoparticles.
Everything.
Right.
So a loss in Delaware wouldn't just cost them money from the COVID vaccine, it could fundamentally kneecap their entire corporate future.
It's literally an existential threat.
So I guess 2.5 billion isn't necessarily an admission that they stole the technology.
Not legally, no. It's the price of absolute certainty. It's a massive insurance policy to clear the legal ledger. They buy peace of mind, they secure the licenses they need for their future pipeline, and they remove the sword hanging over their heads.
Precisely. And furthermore, the settlement resolves the litigation globally.
Oh, because they were fighting in other countries, too.
Yeah, patent rights are territorial. Genevant and Arbutus weren't just suing in Delaware. They had the ability to enforce their patents in Europe, in Asia, and across various international jurisdictions.
And fighting parallel lawsuits in half a dozen countries takes a huge toll on corporate resources.
Huge. By settling for $2.5 billion, Moderna secures global freedom to operate. They can now focus purely on the science and commercialization of their pipeline, rather than spending the next decade tied up in appellate courts.
Which brings up a really striking detail from the sources. It's a fascinating structural reality about how medical innovation actually works.
Yeah, it really changes your perspective.
I think we all grew up with this deeply romanticized idea of the singular inventor. We picture someone peering into a microscope at 2 a.m., yelling, "Eureka!"
Right, the lone genius.
And suddenly we have a new cure. But this case proves that a single modern product, like a vaccine, rarely comes from just one lone genius. It relies on multiple intersecting patented technologies developed by completely different companies.
Do often kind of hate each other?
Yeah, exactly.
If we connect this to the bigger picture, the era of the lone genius discovering a cure in a petri dish is really a historical artifact now. We are operating in the era of platform technologies.
Platform technologies.
Yeah. A platform, like the LNP, is a foundational technology that can be applied to thousands of different diseases. When you have foundational technologies, you inevitably develop what economists call a patent thicket.
A thicket, like a dense, tangled brush you have to hack your way through just to get a product to market. It's very much like building a modern smartphone. When you buy a phone, it has one brand name on the back. But inside that casing is a labyrinth of intellectual property.
So true.
One company invents the specific chemical composition of the lithium-ion battery. Another completely unrelated company owns the patent for the multi-touch screen gesture. Another company designs the microchip.
And you can't just assemble the phone and sell it.
No, you can't just throw it together without securing cross-licensing agreements to compensate every single inventor along the way.
Right. But while the smartphone analogy really captures the density of the overlapping rights, the stakes in biotechnology make the patent thicket vastly more complicated.
How so?
Well, if a tech company can't secure a license for a specific touchscreen feature, they can just design a slightly less efficient alternative. The phone still works.
Right.
In biology, you often cannot simply design around a patent.
Because you're dealing with human bodies.
Exactly. If Arbutus owns the fundamental molar ratios that allow an LNP to safely enter a human liver cell without killing the cell, you can't just use a different ratio.
Because the different ratio might be toxic.
Right. The laws of physics and biology severely limit your workarounds.
Which means the patent holder holds an immense amount of power over public health.
Huge power. Patents dictate who can commercialize life-saving tech and under what terms.
If you hold the foundational patent on the delivery term, you essentially have veto power over any company trying to deliver a cure.
Yes, you do.
So, are we risking a scenario where Arbutus, or a company like them, becomes essentially a patent troll, where they stop actually innovating and just sit back waiting for other companies to invent brilliant mRNA therapies and then jump out from under the bridge to demand a toll?
It is a totally valid concern, and it represents the core tension in intellectual property law. Patents are explicitly designed to be a temporary monopoly.
Right. They expire eventually.
They are the reward society gives an inventor for sharing their blueprints with the world. Without that reward, Arbutus never would have spent 20 years and hundreds of millions of investor dollars perfecting the LNP in the first place.
Because why bother if anyone can just copy it immediately?
Exactly. You have to incentivize the hard, unglamorous, foundational work. The tension arises when that foundational patent covers a technology so vital that it begins to act as a bottleneck for downstream innovation.
Right, because if I'm a startup working on, let's say, a revolutionary new gene editing therapy using CRISPR, I still have to deliver my CRISPR payload into the cell.
You still need a truck.
I still need the truck. I look at this $2.5 billion settlement, and I realize before I can even begin clinical trials, I have to navigate the LNP patent thicket. I have to negotiate with Genevant or Arbutus or Moderna.
And the legal friction is enormous. Without proactive licensing agreements, companies face years of expensive litigation. It forces biotech companies to spend as much time optimizing their legal strategies as they do optimizing their molecular compounds.
Which is wild.
And this is why the concept of cross-licensing and patent pools is becoming a major topic of discussion in biotech boardrooms right now.
Trying to simplify the process.
Yeah, the industry is recognizing that if every single component of the payload, the delivery mechanism, the manufacturing process is guarded by aggressive litigation, the cost of developing new medicines will become entirely unsustainable.
Nobody would be able to afford the R&D.
Right. What this settlement really highlights is the urgent need for a more streamlined framework for licensing foundational platforms. The $2.5 billion figure basically sets a benchmark.
It tells the market exactly what the invisible architecture of medicine is worth.
Yes. It values the delivery truck just as highly as the cargo.
So understanding intellectual property isn't just for corporate lawyers. Whether you're a business owner, an innovator launching a product, or just a patient seeking care, the patents surrounding the components of an invention are just as critical as the final product.
Absolutely. Major IP battles are fundamentally shaping the future of healthcare.
It's incredible to think about the journey we've mapped out today. We started way down at the molecular level, looking at a fragile strand of mRNA.
Too fragile to survive on its own.
Right. We looked at the brilliant, decades-long engineering of the lipid nanoparticle, those microscopic LNP bodyguards.
The precise molar ratios, the endosomal escape mechanism.
We saw how the exact math behind that stealth bomber was fiercely protected by Arbutus. We followed Moderna's aggressive legal maneuvers, trying to invalidate those patents via the IPR process so they could operate freely.
And when that failed, they faced a Delaware courtroom.
Yeah, a jury trial that threatened their entire corporate pipeline. And to avoid that, they wrote a $2.5 billion check to buy the ultimate strategic asset, which was certainty.
And as new technologies emerge, the role of patents in determining public health access will only grow more complex. The landscape of genetic medicine is expanding exponentially right now.
Moving toward personalized medicine and all that.
Yeah, highly personalized therapies, tailored cancer vaccines, in vivo gene editing. Every single one of those advancements will require advanced delivery mechanisms.
So the trucks are only going to get more important.
Precisely. The legal architecture dictating who owns these platforms and who has the right to build upon them will shape the speed and the cost of every major medical breakthrough over the next 20 years.
Which leaves you as a really profound question as you navigate the news of the next big medical breakthrough. If a single life-saving treatment requires a flawlessly negotiated, complex web of intersecting patents from dozens of competing companies,
it makes you wonder.
Could the sheer density of our intellectual property system eventually become a traffic jam? One that actually slows down the next life-saving treatment from reaching you?
It's a real possibility. Could the next cure for a rare disease remain stuck in a laboratory, not because the science failed, but simply because the companies couldn't agree on who owned the rights to the microscopic delivery truck?
It really is the invisible legal friction shaping your healthcare. Something to deeply consider next time you read about a medical miracle. Thank you for joining us on today's Deep Dive. Stay curious, keep asking questions, and we will catch you next.